Hi, folks. We're going to talk quickly about re-verification of employment authorization and inquiries by government entities into hiring practices of non-U.S. citizens. The permanent resident green card holder, U.S. citizen, basically have employment status for life, assuming the permanent resident is not deported or somehow abandons that status, and assuming the U.S. citizen is not denaturalized, which are very rare occasions. But those with work permits, employment authorization documents, and work visas will have expiration dates. There's no work visa that goes on forever and ever. Neither is there an employment authorization card that has no expiration date. Most of those cards have 1 or 2 year expiration dates, and all visas have expiration dates. Now, many visas can be renewed. The H-1B can be renewed for a second 3-year period. The some of the other visas, like the NAFTA visa, can be renewed indefinitely as long as that treaty is in place. So every visa has different renewal. Some visas cannot be renewed. The HR professional needs to understand when a work visa has expired and needs to confirm that the worker has renewed it. Same with the work permit. The work permit needs to be renewed. And this is known as the re-verification process, where you want to calendar the expiration dates of these employment authorization documents and then work with the employee to ensure that that person can provide proof that the employment authorization has been renewed. On the I-9 form we spoke about last week, there is a small section, I believe on the bottom of page 2, called re-verification, and that's where the HR professional can note that the documents have been re-verified. Every once in a while, and this is very rare, but there can be workplace raids, and that's if Department of Homeland Security believes that an employer is hiring undocumented people, and usually knowingly. But it doesn't have to be knowingly. But they believe there's a large group of undocumented people working, there can be an ICE raid, and you would be, as an HR person, very central in that process. They would be, the people raiding the office would ask for your I-9 forms and your HR records, and you'd be obliged to obtain those or to divulge those, assuming there's a appropriate search warrant issued, and you'd always want to ask for the search warrant. If a raid happens, be calm, be respectful, be polite, ask to see the search warrant, and contact an attorney. Normally, you don't have to submit anything immediately. You usually can have time to respond, and you always want to take time. I think there's statutory rules allowing for time to respond, so don't let anybody pressure you into giving documents or information right away before you can speak to an attorney or get your act together. There's also something that Social Security Administration issues more frequently than raids, known as a Social Security no-match letter. And if the information you put on a Social Security number with taxes, for example, payroll taxes, doesn't match the person's name in their system, they're going to send you a letter saying, figure this out. Why is there a mismatch here? And many times somebody's using a false Social Security number or a Social Security number that belongs to somebody else. If that's the case, and you can't remedy the situation, it's most likely required that you have to terminate that employee who's working under an assumed name. However, before you do that, you want to spend a lot of time working ideally with an attorney to figure out if there truly is a problem or a fraudulent issue, and try to remedy the situation and fix it. Sometimes the government is wrong. Sometimes they issue a letter thinking there's no match, and in fact there is a match. So again, spend a lot of time carefully examining those documents. There's an example of the no-match letter on your course materials. Thanks so much. See you next time.